morning. This is Diana, and we're going to talk about deeds today. Deeds of conveyance and the different types of deeds that are available to you, the public. And some of these are used strictly involving a closing. Sometimes it's because a party has an interest in changing title, the way they may have received something, they want to alter it for some reason. First of all, when we do a standard closing, in most cases, if it's a person to person or a company to a person, we use a standard statutory warranty deed. This means that the property is being conveyed, insurable, and they are standing behind the seller, the conveying party, grantor, is standing behind the title and attesting to the fact that they have all right to convey same. If we look ahead a little bit further, there are many other deeds that people use. For instance, similar to the statutory warranty deed would be a trustee's deed. Of course, naturally, that would be used in the case where there's a trust involved, and a trustee is conveying property out of the trust. We also have another document called a personal representative's deed. This is the same thing in essence as a statutory warranty deed, and again, is titled just to signify that it has come out of an estate and that the personal representative is conveying title out. There are many details to be sure that we cover when we're doing a deed. For instance, for underwriting purposes, they do like us to indicate that this is an individual as well as what their title may be. For instance, if it was coming out of a trust, we would want to indicate individually and as trustee of, or co-trustees of if there are two trustees. In addition to that, we like the individual's marital status to be stated so that it's clear that no spouse or family member would have some sort of ambiguity of rights to that property. Taking this a step further, many times people have already been vested in title. They look back on what's going on in their life at that particular moment and they decide that they may need to transfer title. They might want to put it into a trust of some sort. The more common one would be people who want to transfer it because they want to do what we would entitle estate planning. And this is where we try to make sure that they're fully aware of what's available to them. Mr. and Mrs. Smith purchased a piece of property. They bought it and it was titled in both of their names as husband and wife. Perhaps Mr. Smith has passed. Mrs. Smith is alone on title after certain documents are recorded to clear it. This is not considered a probate, it's just clearing title. And then Mrs. Smith wants to be sure that in the least complicated way, it passes to who she wishes. What we can do for Mrs. Smith is add somebody to title. And in the same fashion, it would be joint tenants with rights of survivorship. Now, if Mrs. Smith wants to still retain all of the powers and continue moving forward, knowing that the property will go on to the person or persons she designates, then she can do it in a little different way. We call that a ladybird deed. And this has special language in it which allows her to retain a life estate for herself until the day she dies, and it shows that there's a remainderment. Whether it be one person or several people, they would all be stated with their marital statuses. And in addition to that, the ladybird deed would contain clauses showing that Mrs. Smith has full rights to anything and everything involving the property, meaning she could sell it if she wants to, she can rent it if she wants to and earn income from it, she can do anything she wants and not need the assistance or the cooperation of those parties named as a remainder. This gives her the comfort of knowing that there is not going to be the need for a formal probate of any type, whether that be summary or formal administration, and the property will pass to exactly who she wants. Naturally, if she sells it or she rents it, of course, there would be certain things to look at if, in fact, Mrs. Smith were to pass. But if she still owns at the time of her demise, and this is the manner in which she held title at that time, it would pass freely on to those remainders, and they would at that point in time become vested in title, which means nothing that they do until such time that they become vested will impact her ownership rights or the property itself. So they cannot, their personal issues cannot lean upon the property because technically they don't own it until she has passed. This is one of the things that people do not seem to be fully aware of. It's helpful when people are trying to do estate planning. And in addition to that, of course, there are other deeds that we can do, quitclaim deeds, which most people refer to on a very free basis. We hesitate deeding into from a quitclaim only because it doesn't provide any backup to the party who is receiving it. So, for instance, if, again, we'll use Mrs. Smith as an example. Mrs. Smith owns a piece of property. She wants to put it into an LLC or some other entity. And she says, could you do a quitclaim? And she's going to be the only person on that LLC, or maybe she and one of her children, hypothetically. We would probably suggest to her, do a warranty deed conveying the property. Because as long as Mrs. Smith is still involved in the transaction, she still holds a beneficial interest. It would be better for her if she tries to maintain and preserve whatever title insurance she may already have on the property by not using a quitclaim, which will provide no reinforcement to her backing up the title when she conveys it. This is just a suggestion. It's not a guarantee. But it provides a little bit of security, and hopefully, if there were ever a title issue, the title insurance will still stand behind Mrs. Smith and her policy. We, again, don't guarantee that, but it doesn't take any extra effort for us to perform it, the transfer into a warranty deed rather than a quitclaim deed. And for those of you that are not clear, it is quit, Q-U-I-T. I know it sounds like quick, but it's not. I guess for today, that's just about it, but that covers some of the deeds that are available to you. And hopefully, if you need any further assistance, you can contact me. I work primarily with the Grand Realty agents here in Aventura, and we would love to assist you in any way that we can. We do have attorneys available who can counsel you should that be needed. Thank you very much.